Okay. So we are now on a second case on the docket, which is Jones versus Ford Motor Company, 242985. Counsel for the appellant, you may proceed when you're ready.
Thank you. Good morning, Your Honors. May it please the Court, Tom Sider with Brannick, Berman, and Sider for the plaintiffs. If I may, I'd like to reserve 5 minutes for rebuttal.
So noted.
Plaintiffs appeal in order denying leave to amend to assert a claim for punitive damages. In that order, the trial court considered the wrong evidence, applied the wrong legal standard, and ultimately reached the wrong result. This court should reverse and remand so that we may plead a claim for punitive damages. And that's where we are in this case. We are still at the pleading level. 768.72 is concerned with setting a heightened pleading standard. We are just trying to get in the courthouse doors. We're not trying to go any further than that. I'd like to start today with what I view as kind of one of the court's structural errors that was committed below, which is the trial court's consideration of the counterproffer presented by Ford. Without Ford's counterproffer, I don't think that there's really any question that we made what would be considered a sufficient proffer to create a reasonable basis for the recovery of punitive damages. And so I think that the counterproffer is really a load-bearing component of the trial court's ultimate conclusion here, which is why Ford pushed so hard below for the trial court to consider the proffer, and that's why the court relied on it so heavily in the order under review.
Counsel, I understand your statement that this is a pleading matter. There's really no reason to ever get the defendant involved in a pleading matter, but we have the statute. We have a special standard to allege a count of punitive damages. Why is it not appropriate? I mean, considering that they say, evidence in the record or proffered by the plaintiff, why isn't it appropriate to say that, well, yeah, that includes any evidence in the record, which would include something that the defendant has to say, not necessarily to add new evidence, but to maybe give context to the appellant's reasonable showing. Isn't that kind of what the statute? I agree that as a general principle, the defendant doesn't have much of a say in the support for allegations in a complaint. But we have a statute that gives a higher standard. Why shouldn't it include this?
Well, Your Honor, I think that for the answer as to why it shouldn't include this, I think the plain statutory text doesn't allow for it. And we would agree that there is a heightened pleading standard. When you are pleading something in a complaint, you need to have a good faith basis, basically non-frivolous basis. What the legislature has done with 768.72 is it has imposed a reasonable basis standard, and a reasonable basis that needs to be supported by some sort of evidentiary showing. I think the petitioner in Perlmutter called it a show your work requirement. It's not enough to just say you have to present some sort of evidentiary proffer. But when you look at 768.721, what it says is, no claim for punitive damages will be permitted unless there is a reasonable showing by evidence in the record, proffered by the claimant. The claimant is the only
It says
party.
or proffered by the plaintiff.
I'm sorry,
by the
yes.
claimant.
Yes, Your Honor, that's right.
So I agree, a proffer is a proffer, but it's tough to ascertain what the word reasonable can be, and in this case, what evidence in the record means. There's rarely a lot of evidence in the record at the pleading stage, but it seems like there's at least a suggestion that at the very least, the defendant, I'm just trying to get a scope of this, that at the very least the defendant could suggest that the evidence that the plaintiff is attempting to use to support their reasonable basis is false. It's taken out of context, for instance. Whether they can add completely new information is another question, but what about that? What about just simply challenging?
I think challenging the evidence would be appropriate, the evidence presented. I don't think that the defendant has to sit on their hands at the hearing and just accept as true. But it's different to challenge evidence as speculative or insufficient. That's one thing, and it's an entirely other thing to allow the defendant to present its own affirmative evidence that the defendant claims is going to counteract or rebut what the plaintiff has shown. And the statutory text here, it only mentions the claimant. It would have been very easy for the legislature to provide for a means by which the defendant can present evidence. That's what happens in the summary judgment rule. There is an initial burden, and then there is an opportunity for the non-moving party to present evidence too, and then the trial court considers that sort of those conflicting evidentiary proffers. There's nothing like that in this statute.
It's also like that in the, was it nursing home statute?
Yes, Your Honor, exactly right. In the nursing home statute, which was written well after the 1999 statute that's at issue here, there the legislature goes out of its way to say evidence by the parties, which could have been done here. And as a matter of sort of textualism, the fact that the legislature in a later statute thought it needed to add that language shows that it was an intentional departure from the general punitive damages statute that's existed for quite some time before that. So I think
Do we know what the legislature was thinking in 1986 based on something the 2014 legislature did?
I don't think that we know necessarily, Your Honor, and I don't think legislative intent is usually something that we are overly concerned with from a matter of textualism, but it is a method of statutory construction. We assume that the legislature makes changes knowingly, and that's what the legislature did here. And if the legislature in the 80s or in 1999 wanted to allow for the defendants to make countervailing, sort of evidentiary showings, it could have, and it didn't here. And I know that there's a discussion in the briefs about the nearest referent canon, and I don't think that we need to get into all of that here necessarily, but I do think it is worth noting that the phrase "by the claimant," that is modifying not the word proffered. It is supposed to be modifying the reasonable showing, and this statute is set up in a way where it is saying, here is what you need to show in order to establish an entitlement, or rather, the entitlement to plead punitive damages. It would make no sense to read the statute as allowing for the non-claimant to be making that showing. The non-claimant has no interest in making a showing that would support the pleading of punitive damages. So that's another reason why it does not make any sense to read the defendant in as an implied actor when the legislature does not mention the non-claimant, does not mention the defendant once throughout the entire statute.
But it is, and I think you've already conceded this, it is a heightened pleading burden, right? And so let me ask you this, to what extent, when a trial judge is determining whether there is a reasonable showing, should he or she be informed by the clear and convincing burden that's in subsection 2? And then related to that, to what extent can the trial judge consider any evidence in the record in terms of showing whether and determining whether there's a reasonable showing?
Yes, Your Honor. To answer the first question first, the parties here agreed that unlike the Perlmutter 4th DCA sort of formulation of the statute, that the trial court is not supposed to be taking the clear and convincing evidence standard into account at the pleading stage. At the summary judgment stage, that would be proper, but at the pleading stage, it would not be. So that's why we haven't briefed that issue, and that's not the conflict with Perlmutter that we think exists in this case. It's just the sort of counter-proffer issue.
Can we back up just to the I guess, plaintiff's initial burden? When you're attempting to prove gross negligence, what is the actual defect that you're claiming, Ford's product had?
Yes, Your Honor. So the defect here is that Ford installed airbags into their cars with inflators that allowed the intrusion of moisture that degraded the ammonium nitrate in the inflators, and that resulted in, over time, what they called energetic disassembly, which is explosion. It turned these inflators over time, especially in hot and humid climates, will degrade, and they turn into effectively live grenades that are sitting there in an airbag.
And so, if the problem is that, okay, ammonium nitrate, I guess, gets way too explosive when it absorbs moisture, and I'm reading sort of the motion on appendix page 16 and 17, is the defect at issue here the use of ammonium nitrate in general?
It is the use of ammonium nitrate with, I think, a quick way to say insufficient sealing that allows for moisture intrusion. If it didn't allow for moisture intrusion, then you could, in theory, make, and other manufacturers have, they've made safe versions of ammonium nitrate inflators. It's expensive, but the inflators here, they don't keep the moisture out, and as a result, they are unsafe.
And I see that in the initial brief is where you say, okay, the problem is the moisture intrusion, but where in the motion to amend did you say that's the defect? It's not ammonium nitrate in general, it's the poor sealant around it.
I think that in our expert affidavit, and I don't have the records right in front of me, Your Honor, that is what Dr. Blomquist said was the defect. It's those two things combined. But it is the ammonium nitrate that presents the real danger here.
And that's what I'm trying to get at. When we're reviewing the trial court's decision, and you tell the trial court, look, it's the use of ammonium nitrate, period, that's the defect, then how can we go and sort of narrow the problem on appeal? Is it just based on the expert?
I think so, Your Honor. I think the expert said it, and our proffer is trying to give a representative example of what we're going to show at trial. And to be sure, the ammonium nitrate is the defect here. It is the fact that it degrades. It is the fact that it explodes. A contributing cause of that is the moisture intrusion. But I think at the proffer stage, we've shown more than enough to give at least a reasonable basis for recovery of punitive damages. And if this were a matter of ultimate proof, I think it would be a closer and different question, but we aren't there yet.
Okay, so,
Go ahead.
I'm sorry. So if the issue, I get it, the issue is the propellant, that's a defect, that's what you're seeking recovery based on. But of course, this is about gross negligence. At what point are you alleging that that defendant was grossly negligent? Not just that there's a product defect that could result in liability, but that they were grossly negligent, which is, of course, the main reason we're here.
Yes, Your Honor. I think there's two main inflection points that we highlighted below. And the first is in 2004, when 10% of these ammonium nitrate inflators end up exploding during testing.
Whose testing was that? Was that Ford's testing?
It was Ford and
okay.
Takata doing the testing sort of together.
Okay,
in
got
tandem.
it.
But
Yes,
that
Your
was a different model, correct?
It was a PSDI 5, and the inflator that exploded in Mr. Jones's truck was an SDI. Our position is they are not materially different at all. They have
No, go ahead.
they have the same defect. First of all, it's exactly the same thing. And then also, the evidence here is that they're in the same inflator family, and they have the same formulation, is the quotation used. But they use the same propellant tablets. They look kind of like aspirin, but they're in both. So our position is they are not meaningfully different at all, and that this testing should have put Ford on notice, and did put Ford on notice, that there is a problem with this type of Takata inflator, and that they should not have done what they did, which was fail to conduct adequate testing. They did abbreviated testing, and they forced this inflator through because they didn't want to miss a production deadline.
Can we talk about the test in 2004 that supposedly gave Ford this knowledge? The test results conclude the root cause is moisture produced by auto-ignition material. Now, is that moisture that comes in from the outside through a poor sealant, or is that moisture that was internal already in the manufacturing process?
That's a good question, Your Honor, that I don't think was especially developed below, but my understanding of the root cause analysis from 2004 is that it's moisture intrusion. The point of the test that they were running was to see what happens to the inflators over time in the field.
Do you know if the SDI inflators also have this auto-ignition material?
I do not know, Your Honor, and I'm not sure if that's apparent from the proffer. And I'd argue that this is sort of the very technical, granular sort of facts that would need to be developed through discovery. That could be a proper target of a motion for summary judgment, or developed at trial. And we're now kind of moving past what we would need to, what would be a reasonable basis, and now we're into the
Yeah,
sort
well,
of,
what we're trying to decide is it reasonable for a fact finder to take this test result for the PSDI-5 and infer the same defect or cause of the problem with the SDI? And so I'm asking for you to help us bridge that gap.
Yes, Your Honor. Our position is that the root cause identified in 2004 is identical to the root cause that was determined later by Dr. Blomquist when he was working for a kind of external regulatory group. And it is identical to the defect that ended up killing Mr. Jones. And if I could, I'd like to talk about what we view as kind of the second inflection point. You know, Ford has this 2004 testing where a frankly unheard of number of inflators explode. They are a late adopter, Ford is, to the Takata airbags, which means that other manufacturers started much earlier, and other manufacturers' Takata airbags start to explode in advance of Ford's, because this is a sort of drawn out thing. The vehicles need to be in the field a certain number of years. And so as Ford is sitting there watching, as Honda and Toyota and Nissan vehicles, as they start to have the exact same, exploding inflator problem that they noted in 2004, that's when alarm bells should be going off. And in fact, were going off at Ford. Ford is watching the thing they were worried about in 2004 happen in real time, starting in 2008. And it's not until 2016 that they do any kind of a recall, and it's not until 2018 that they do these sort of heightened, more performative recalls with the, very graphic warning. So that's 10 years. Even if you put 2004 aside, that's 10 years of them watching and internally saying, uh-oh, this is the thing we were worried was going to happen is happening. And it happened with PSTI inflators, it happened with STI inflators. And they did not do a single recall or warning until one of their customers died. And our position is that is, on its own, a reasonable basis for the recovery of punitive damages. A jury could look at that and say that is grossly negligent. That shows a conscious disregard for the safety of your customers.
How do you place Ford's conduct, the recall conduct, in what you might think of as the chain of causation between its conduct that ultimately killed Mr. Jones?
Yes, Your Honor. So I think what a jury would be able to look at here is, we don't know exactly how many, we of course don't believe the counterproffer should be considered at all, but in the counterproffer there's these recall notices that were supposedly sent out. And we admitted at the hearing, at a certain point in, I think, 2022, there was a recall notice that Mr. Jones's girlfriend was texting about. And so, to answer your question, I think the causation analysis that the jury is going to do is, if those recall notices started going out a decade earlier, is it reasonable, is it reasonably probable that the recall notices would have reached Mr. Jones or his mechanic? Would it have made a difference? And I think it's entirely predictable here what happened, right? Every year that you put off doing a recall notice is time that is going to be potentially lost in reaching somebody with a recall notice. What we cited in the brief, there's a whole bunch of people, just people that I think, frankly, trial counsel represents already, who were in a similar situation to Mr. Jones, who are being killed in 2022, 2021. It's after the recall notices, but if those notices had gone out earlier, they could have been reached. This is something that happens and is predictable and is foreseeable. And
Counsel, my recollection was that the argument was made that the fact that Mr. Jones may have ignored the recall notices goes more to a comparative fault analysis than whether you're permitted to plead punitive damages. Is that correct?
Yes, Your Honor, that's basically our position.
So what that leads to the question of is, does comparative fault apply at all to punitive damages?
I think it does. It does not, Your Honor. I think what Ford is arguing is basically 100% of the fault goes on Mr. Jones. And if that is true, then I think you could argue that there's not a causal sort of nexus between the punitive conduct and the injuries. But ultimately, that's a question for a jury to decide.
So if he seeks $1,000 in compensatory damages, jury finds him 90% responsible, so he's only entitled to $100, but he can still get $1 million in punitive damages.
Theoretically, yes, Your Honor, subject to
It doesn't matter
the
that
due
he
process
was
clause.
90%.
Well, it potentially will matter in assessing whether the punitive damages award is excessive. There's a the punitive damage statute has a cap, I think, on compensatory punitive damage. So that's sort of built in to I think, alleviate the concern you identified. If I may, I'll try to save the little time I have left for a very quick rebuttal.
Look, Counsel, we had a lot of questions for you. We'll extend your time by 5 minutes. We will provide the same courtesy to counsel for the appellee.
Thank you, Your Honor. I appreciate it.
Good morning, and may it please the court. Alina Rodriguez and Wendy Lumish on behalf of the Ford Motor Company. I'd like to start by addressing the court's inquiry regarding what it can consider. And as the court knows, we really have three, and they're set out in our brief. We really have three reasons why it is that the court could consider, the trial court could consider our evidence. But ultimately, what I want to clarify and what I want to make sure is clear to the court is that even if you just consider plaintiff's proffer, plaintiff's own proffer establishes that it's what it doesn't establish, and that is that the conduct rose to the level necessary for punitive damages. So if you look at the statute itself, Judge Winokur, it does create two separate types of evidence: evidence in the record and proffered by proffered by the claimant. We know that because the corresponding rule of civil procedure expressly says evidence in record or evidence to be proffered by the claimant. And Judge Ray, your point of how is a court to determine whether a proffer establishes a reasonable basis without looking at all of the evidence. The third point as to why the court can consider our evidence is really that if you look at the framework in which this particular issue arises, you're looking at heightened, it is a pleading standard, but it is not a factual pleading standard. It has a significant evidentiary component. And the reason for that is because Florida, both legislatively and judicially, has recognized that these are, as we quote in our brief from certain cases, these are game changer issues.
Let's focus, and I appreciate that, and
Yes, ma'am.
we're well familiar with the reason for the statute, but just textually, we know that proffered has an agent, right, identified agent, it's by
Yes.
the claimant, but reasonable showing by evidence in the record does not. So who is to make that showing but the claimant?
Well, the record is neutral. And so the fact that the court did not specify indicates that record evidence belongs to the court. Record evidence belongs to the case. Record evidence is not tied to a party. And so that is why we believe, and I think that is what the Perlmutter en banc decision ultimately held, that the record is expansive enough to include everything.
Well,
Go ahead.
but that's, record for context is one thing, but a counter proffer to me seems to be quite another. And let me ask you this, what are we to make of the nursing home punitive damages statute that expressly allows for both parties to play a role?
I don't think you can make anything out of the fact. I don't think you can make anything in terms of what was happening in 1986 because of something that went on, however many, 20 years later. So I don't think there's anything that you can make of it. Like I said, I do think that if you look at the totality and you look at the reasonableness inquiry that the court has to make, and more importantly, you look at the gatekeeping function that everyone agrees that the trial courts make, right, with respect to these amendments. How is the court to properly make a gatekeeping assessment without looking at everything in context and with other evidence? And I want to be clear, it's not, there might be decisions or there might be issues with respect to whether that means that the court is weighing the evidence. It does not mean that. And we were very clear that...
Well, let me ask you one more question about the text
Yes, Your
of the
Honor.
statute that kind of worries me, because what it says is that it has to be a reasonable showing by evidence in the record or proffered by the claimant, which would provide provide a reasonable basis, not whether there is a reasonable basis, based on, competing positions of whether there, but whether it would provide, which tells me that it is about the plaintiff, whether the plaintiff has provided a reasonable basis. So I don't think there's anything wrong with the defendant arguing that the plaintiff's basis is wrong. But it strikes me as maybe contrary to the statute for you to offer completely separate evidence to demonstrate that the basis isn't reasonable. In other words, you're no longer determining whether the plaintiff has provided a reasonable basis or not. You're just simply trying to tell the court whether or not the basis is reasonable. Does that make sense?
I think I understand the question. If you look at what was actually in our, in our proffer, in Ford Motor Company's proffer of evidence, so this is what it added. It added an affidavit from an engineer who was intimately involved, Mr. Krishnaswamy, with this process. And he explains how the SDI inflator, which is the subject of this case, passed all of Ford's testing. And he explains why the PSDI-5 is a different type of inflator. Now, what's interesting about that, and this lets me circle back, and I hope I'm trying to answer your question, but what it does is, well, and the other thing I wanted to say, the other thing that is in our proffer that is nowhere near to be found in in our presentation, in their proffer, is the over 200 outreach efforts that Ford undertook to prevent this exact thing that happened. And so you wouldn't have known about that. The court would not have known about that, but for Ford putting that evidence in. That is something that truly is really you're only going to find it in our evidence. And so when the court is determining whether there is sufficient evidence to present this to a jury, why plaintiff's position is that the court has to put on blinders and say, plaintiff picked A, B, C, and even though there's all this other evidence, I can't look at it, but a jury's going to get to look at it. So then we're engaging in an exercise in futility where we are exposing defendants to, or parties against whom punitive damages are sought against, to exactly what the legislature and exactly what the courts have said we don't want to do. That's why there's a gatekeeping function, and that's why.
To follow up on your point there, how do we reconcile that with the notion that the trial court must consider the evidence of the movement in the light most favorable to the movement? And so
Yes.
To the extent there was conflicting evidence on whether the PSDI-5 inflators were materially different in any significant way, and the trial court concluded that they were not. Why is that not weighing evidence or considering evidence in a light that's not the most favorable to the movement? Correct.
I think, Your Honor, Judge Treadwell, you brought it up, and I'm looking at, for example, to go back to the example of they really talked about two things that they say shows Ford's state of mind, right? And one of the things was this PSDI-5 testing. And if you look at the appendix at Appendix 633, and I think, Your Honor, this is what you were referring to. So what it shows is, well, first of all, that it is a PSDI-5 inflator, and then the root cause, as the court pointed out, or now I can't recall if it was Judge Turtle or Judge Winokur, it's talking about the moisture produced by auto-ignition material. That is coming from inside the inflator. Okay, this is their proffer. This is not my counter evidence. This is not Ford's engineer explaining why this doesn't make any sense. This is from the paper that they proffered itself. They're not talking about environmental moisture coming in because the sealant was not appropriate or what have you. They're talking about this AIM. AIM is auto-ignition material coming from inside and causing the moisture issue. This cannot possibly put Ford on notice, Your Honor. And this is not an issue of this is not an issue of the light was red, the light was green. This is an explanation for this, and it is in the paper in black and white. The other thing that plaintiff pointed to was Ford's conduct in 2008 when And I do want to note this on this particular point. If you look at cases like Chrysler v. Wilmer, the court there expressly, and that's a 1986 Florida Supreme Court case, they went through and they said the plaintiff is saying that the manufacturer was on notice because there was this test result and that test result and this test result. And the court very carefully says, but when you look at those tests, they don't, and they go through each of them, I'm summarizing it, they don't stand for what the plaintiff is saying they stand for. So I think on the basis of Chrysler.
Is that a pleading case or
that
a
case, I
case
believe,
challenging a judgment?
it was challenging a judgment, but at the end of the day, it's as a matter of law, Your Honor. They were saying that the issue shouldn't have gone to the jury. So if I can turn real
Is
quick.
that the same thing? The issue shouldn't have gone to the jury means that it can't be alleged in a complaint?
Well, I think to the extent that you're dealing with issues as a matter of law, I think they're very similar, yes. Turning to the other point.
Before we turn to 2008,
Yes.
can we stay in the 2004-2005 time
Yes.
frame? And the appellants point to the deviations from the USCAR standards. So why isn't that, a reasonable showing for punitive damages?
Because that's another part of the same, it's the same issue, Your Honor. The deviations, what they don't explain to you, and again, I'm gonna rely on one of the memos that they cite with respect to the deviations. It's at Appendix 455, and it was a memo regarding a meeting with Mr. Marshall Quaid. First of all, the deviation, the short answer is the deviations had nothing to do with the ruptures that were eventually taking place. And second of all, they were deviations that were not unique to Takata. All of the manufacturers required deviations. But going back to what plaintiffs are talking about and Mr. Quaid's supposed concerns, at 455, you'll see that in the summary that Takata put together, they're saying his concerns are effluence, which is basically the toxicity of what's going to be released, and Ford was concerned about, this is in their proffer as well, Ford was concerned about asthmatic occupants and how that would affect them, and flaming, which is a component of, it's something that happens when the airbag activates, that you see some flames, and there are regulations in terms of how much flaming you can see. Those were Mr. Quaid's concerns regarding the U.S. car specifications and the deviations that were needed. He also talks about tunability, which is, it's not a U.S. car deviation, but that's the third concern, and tunability relates to making sure that the bag can be used in multiple size vehicles, so from a sedan to a big 7-seater SUV. So that's at 455 in the record. May I turn to the 2008? Yes. So when that started, when Honda had their first ruptures, Your Honor, first of all, the record is, and again, from their proffer, the record is that Takata was telling Ford, not your inflators, this was a manufacturing issue, you are not affected by it. And that's at 1123 in the appendix and at 958 in the appendix. And really, we know that that's accurate because at the end of the day, in 2017, Takata entered a guilty plea. I don't know if it's a guilty plea, but entered into a plea agreement with the Department of Justice and agreed to pay $1 billion in restitution and fines because they were lying to all the OEMs. Because this was...
And that, was part of the time frame of the recall. So let me ask sort of a two-part question.
Yes.
What is your understanding of the defect at issue in this case, and then what was the defect that ultimately caused Ford to recall these vehicles?
I think when Your Honor asked the question, we had the same thought of, it's somewhat fluctuated what plaintiff is saying, because at first it did appear that they were just talking about the mere use of the ammonium nitrate, right? The phase stabilized ammonium nitrate. Of course, they had to walk away from that because their own experts spent 20 years at TRW building inflators with PSAN components. It's now on appeal morphed more towards the housing of the product of where the product is, where the PSAN is housed. So there's not I don't think the record is sufficiently developed to be able to answer that, but the more, I guess, overarching answer is that we are at this juncture not determining whether there's a defect or whether there's a defect or not a defect. We are talking about whether they have put forth a reasonable basis on Ford's state of mind, that it was because they're going under both intentional misconduct and the gross negligence misconduct. So what we are focusing on, what we are focusing on is really Ford's state of mind. That's what they have to show. That's what they had to show to the trial court.
Did Ford recall the entire, 2004 family, the Takata family that's talked about in these briefs?
The Takata family is a Takata kind of, I guess, nomenclature. But yes, ultimately, so this particular, I can talk about the SDI specifically. And yes, I believe all the SDIs were recalled. The SDIs, when the first rupture happened, Ford issued a recall immediately. And when the second one happened, they issued this extraordinary effort called a do not drive. And that is when, from 2016, one was in 2016, one was in 2018. But from 2016 to the time of this accident, that's where you have all those outreach efforts that you have over 200. And one of the things that's interesting is plaintiff says the court weighed evidence. Well, what the court actually said was it only gave, I guess, effect to the two that plaintiff agreed they had gotten. And they had to agree to it because plaintiff's girlfriend, when we took her deposition, and it was actually during the direct examination by plaintiff's trial counsel, where he put this in as plaintiff's exhibit 1, this picture that it's at appendix 2103, this picture that she, when she was living with him, saw the notice and took a picture of it and sent it to him and said, do something about this. So the court only gave...
As Judge Winokur was asking, I mean, how does that go toward the punitive damages question and not merely a comparative negligence question?
Well, a couple of reasons. Because of the particular facts of this case where you have a steady stream of outreach efforts, including a canvasser who went to Mr. Jones's house personally, you have 6 years of outreach efforts. And so our position is that this is not just a matter of ameliorating some sort of fault. This is breaking the causal chain.
I'm sorry, my understanding of the plaintiff's argument, the appellant's argument, is that, I mean, I know we have this failure to warn in time, but setting that aside, that the gross negligence occurred in 2004, 2005.
Well, of course.
By permitting these inflators into the Ford Ranger trucks. Now, if that's the case, if they sell, just presume, that's correct, that was grossly negligent to sell these items in 2004, is really waiting, several years to say, you know what, those are dangerous, we should take them back. Does that ameliorate the fact that you were grossly negligent in selling the product in the first place?
I think you have to, taking the court's hypothetical, I think you have to take into account what was going on during that time. And what was going on during that time is, first of all, as I showed the court, I think at Appendix A633, the PSDI testing from 2004 doesn't put Ford on notice. What happens after that is when they start having these issues in 2008, they start talking to Takata. And Takata, this is not a Ford issue, I also want to clarify. This was an industry-wide issue. And Takata's telling everybody, not a problem, nothing to see. But Ford doesn't just take that. Ford initiates these efforts, for example, one of them in conjunction with NHTSA, the National Highway Transportation Safety Administration. And that's, by the way, in the record in their proffer at 1125 and at 1721. No, sorry, 1721 is part of ours, which we think you should consider, but it's otherwise in their proffer. Ford and other manufacturers get together with NHTSA and start this parts gathering process where they go into the field and they gather good parts, and so that they can start investigating. They did that. They instituted an internal task force, and then ultimately, when it was continuing to happen with other manufacturers, not yet with Ford, it got together with a group of other vehicle manufacturers, and it formed the ITC, the Independent Testing coalition. And what that coalition did was, so all this is going on during that period of time. So let me finish with the ITC a second. ITC retained an aerospace company to get to the root cause of this, right? And that company took a year to get to the root cause of this. And at the end of the day, what they determined were the three sort of root cause components to these failures. But by that time, Ford had already recalled all the SDI inflators. And so what plaintiff would have you believe is that Ford sat cross-armed and did absolutely nothing. And their own proffer establishes the opposite. It's not a matter of, it fills in all the gaps that they are not telling you, Your Honor. And it is within their own proffer. And so...
what you're saying is that grossly negligent conduct on the part of the manufacturer can be completely offset by later remedial actions by the manufacturer.
I think that when the remedial actions break the causal chain, yes.
There is no chain. The grossly negligent act occurred in the past.
Correct,
I mean,
but
this is the plaintiff's position. as
correct,
I
but
understand.
there are several components to a cause of action, and causation is one of them. So even if there was a defect, right, or even if there was negligence, you still have, in order to proceed with a claim, you have to to win a claim, you have to establish causation. And what plaintiff is telling you is that, for example, ignore cases like State Farm versus Campbell, where the U.S. Supreme Court says, we're not going to look at what happened with other people. What State Farm versus Campbell is saying is the conduct has to have a nexus to this plaintiff. And ultimately, assuming that there was a defect, assuming that there was gross negligence, which by no stretch would I concede that. I don't think the record supports that. Whatever there was, the causal link was broken in this particular case, and the court should pay attention to the cases. It happened, I think it was at the trial court level. I'm not sure how much they did it in their brief, but for example, they cite to cases like Holmes, where there was, a delay in what have you. But the difference in Holmes is that the accident happened during that delay.
Counsel, I'm sorry to interrupt this chain, but it does relate to a question I have in
Yes.
terms of these arguments sounding like motions for directed verdict type arguments, as opposed to kind of where we are in this appeal, which is there a reasonable showing in the record that there's a reasonable basis for a claim, to support a claim for punitive damages? So help me reconcile,
Yes.
that standard, the directed verdict type arguments, this, matter of the law type arguments versus where we are now in this case.
Well, I think what you can look at, and if I were to summarize the evidence, that the full record that's in front of the court, and what you have is there's no notice. They haven't shown you that Ford had any sort of knowledge. In fact, we know the entire industry didn't have knowledge, and NHTSA and the government were trying to figure it out, and then the ITC retains this company. So there's no knowledge. Your Honor, that's in their proffer that the SDI, the particular inflator in this case, passed a rigorous design verification process. It's at 540.
Is the only evidence of that SDI testing the Krishnaswamy declaration?
No, you can find it at, I have a note here that it's at 540 and a 1092, that it will also say that it passed, that the only failure that they saw in the field was PSDI 5. And we've I think, talked about that one.
So because the SDI passed these other types of tests that
Yes.
Ford conducted, is your position that it is then unreasonable to rely on the PSDI 5 tests?
Well, absolutely. Not to mention that the PSDI 5 test doesn't show what they say the PSDI 5 test. It doesn't show the root cause in this, that is alleged to have happened in this case.
So, and one of the pieces of evidence is the appellant's expert suggested that Ford did not conduct the adequate tests for the SDI before sending it into the marketplace. How are we supposed to view that evidence in the light most favorable to them and still uphold this order?
I think that you have to look at the totality of what we have introduced. First of all, Dr. Blomquist, who I guess at some point was saying Ford knew this and Ford knew that, ultimately in his deposition, which Ford had to significantly request because, and I don't know that this is clear from the record, but it would be exhibited in the record, that plaintiff basically filed a motion for punitive damages, attached a 3-page declaration from Dr. Blomquist and said, here, punitive damages, and tried to block every effort at us getting into anything. Dr. Blomquist, when he's ultimately asked, in his deposition, he says, no, I don't know what Ford was thinking. I wasn't working with them at the time, nor can he, because what Dr. Blomquist and plaintiff would have you believe is that everyone in the industry knew, when there's zero evidence of that, certainly no evidence of that in this record. What Dr. Blomquist would have you believe is exactly that. And so I think you have to measure what he says in light of that. I see that my time is up. Unless the court has any other questions that I might answer, we would respectfully request that the court affirm the trial court's decision below.
Thank you, counsel.
Thank you for your time.
So I want to try to hit as many of these points as I can. Our overall position here is that what Ford is doing is trying to expand judicial review beyond what the statute calls for, which is deciding whether there is a reasonable basis for recovery of punitive damages, and it wants to turn this pleading stage proceeding into a mini trial and wants to ask the trial court and now this court to sort of adjudicate ultimate facts in the case. And I think we heard that today. And as you pointed out, Judge Whitaker, when you look at the statute says you don't get to plead punitive damages. The pleading is not permitted unless. What the statute is setting up is a threshold that the plaintiff has to get past. It is not setting up a rebuttable, a means by which the defendant can make a rebuttal. It is all about a standard that the plaintiff has to clear. That's the gate here, and we have done so.
Can I ask you about one sentence that the trial court included in the order denying the motion?
Yes.
The trial court wrote, plaintiffs present no evidence suggesting that Ford was aware of the problems with the SDI inflator when it decided to use it in the MY 2006 Ford Rangers at issue in this case. How was that an inaccurate statement by the trial court?
Our position, Your Honor, is that the PSDI 5 testing was enough to put Ford on notice that these Takata inflators have a defect. And below, I will admit, there was not this distinction made that you touched on, Judge Treadwell, between where the moisture is coming from. But I would submit that the problem is that it's filling up with moisture, and that when it fills up with moisture, it explodes. And that was a defect that became very apparent very early on in the testing process. And what Ford has not shown, and what the record has not shown, is why it is that it would be okay for the PSDI 5 inflators to explode, and then to take at face value, well then the SDI inflators will be fine because they have a different acronym. I don't think there's anything in the record that supports that, especially when they are, from our perspective, functionally identical in the way that they are defective. And this is a highly technical, sort of specialized question, and one that we would submit is not appropriate now. There is still summary judgment. There still is trial. That's when these questions are going to be answered. And we are just one rung above the normal pleading standard here. We are at this reasonable basis standard, and our position is that we have done at least that here with our showing. I did want to very quickly talk about this idea that the trial court didn't weigh evidence, and I believe my friend said, well, it was made very clear to the trial court that the court wasn't supposed to weigh the evidence. Ford argued exactly the opposite at the trial court. Ford argued, and I think it was at page 1688, it said, punitive damages are different. Unlike summary judgment, you need to weigh the evidence, and you need to make a determination after weighing the evidence. You need to act as the trier of fact. And that is precisely what the trial court did here. The trial court even made comments, I'm having trouble deciding how much weight to put on this piece of evidence that you've submitted in your counterproffer. So, you know, maybe Ford agrees now that weighing the evidence is not proper, but that's not what they argued below. And by arguing that, we would submit that they led the trial court to error.
Was the PSDI 5 recalled by Ford,
Yes, Your Honor.
even after the desiccant had been added to it?
You know, that's a good question, Your Honor. I don't think is apparent from the record. I think that the desiccated PSDI 5s were viewed as probably much lower priority, and I'm not sure if it was ever determined if those are defective, but at a certain point, I think they just pulled every Takata inflator off the market, frankly. But that is a point I guess I should hit on very quickly, is that Ford at some point said, we need to start adding desiccant to our inflators. So they come up with the fix. They say, we need something to soak up the moisture. But instead of waiting until they can put that fix into all of their inflators, they keep producing cars with the faulty inflators because they don't want to miss a production deadline.
Can you point to us where in your motion or your proposed complaint you made an issue of the desiccant?
No, Your Honor, I don't believe we did in the initial motion. It was kind of, you know, the problem here is that the sort of burden has been flipped. We made our initial showing, then the defense comes and tries to disprove everything we do, and unless we can sort of preemptively argue against all of these counter arguments as counter evidence, you know, I think it puts us at a disadvantage. So that was not something we were focused on in our initial proffer. We were just trying to make a reasonable showing and not trying to sort of pre-adjudicate the ultimate facts of the case. I'm almost out of time here, so I would just ask that this court reverse and remand so that the plaintiffs may plead a claim for punitive damages and in the alternative, certify conflict with the other DCAs so that we can seek further review at the Florida Supreme Court. Thank you, Your Honors.
Thank you to both attorneys. We appreciate you coming to Pensacola, and the court now stands adjourned. Thank you.
All rise.